Hello, everybody, and welcome to History/Law Bite number 209, dated March the 11th, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled Giles versus Harris, 189 U.S. 475, 1903. Giles versus Harris was a significant U.S. Supreme Court decision handed down in the very early days of the 20th century, and it surrounded the issue of whether or not a state's voter registration system, which was clearly discriminatory, was constitutional. Giles versus Harris may or may not be a case that you've ever heard of, and if you haven't heard of it, that's perfectly fine because it has fallen into the dusty hole of constitutional law, cases that are no longer talked about or discussed or even mentioned, because it was such a poorly reasoned decision, to say the very least. All right, we've had some bad ones, we've had some atrocious ones, and Giles versus Harris is certainly, gets a silver medal, in my opinion, for being one of the court's low points. Okay, the decision was the court's most recent to date capitulation at that point to the forces of white supremacy. So specifically in Giles versus Harris, we see the results of a new state constitution being adopted in Alabama in 1901. And with that new constitution came a litany of new requirements in order to be able to register to vote. This was obviously an intent upon the state to disenfranchise African Americans. What a novel thing, huh? So, everybody who voted for that new state constitution was quite aware of that, okay? So, because of this very simple thing, these requirements allowed registrars to examine each and every person who was going to register to vote individually, asking them all sorts of questions and making them satisfy all sorts of requirements. And again, the purpose of this was to keep blacks off the voter rolls. Again, what a novel thing, huh? So, in response to, these discriminatory provisions, an individual named Jackson Giles filed suit against the registrars in Montgomery County, Alabama, challenging the constitutionality of these new restrictions in the Alabama state constitution. They argue he filed suit on behalf of himself and about 5,000 other African Americans, argued that these provisions violated the 14th and 15th Amendments to the Constitution of the United States. Okay, and the relief they sought was to simply be added to the voter rolls and have these provisions declared null and void. However, the Circuit Court for the Middle District of Alabama dismissed the suit, holding that it did not have jurisdiction, that the amount in controversy had not been satisfied. All right. So Mr. Giles appealed the matter to the Supreme Court of the United States. All right, where the singular issue facing the justices would be this: did the Alabama provisions, which while neutral on their face, were clear in their intent to disenfranchise African American voters, all right? Did these provisions, all right, were they violative of the 14th, 15th Amendments to the Constitution? And as such, did the Supreme Court of the United States here have the jurisdiction to declare them null and void and grant the plaintiffs relief? All right? In a very, very strange and twisted in logic decision authored by the legendary Oliver Wendell Holmes, the Supreme Court ruled 6-3 that it did not have the ability to order, all right, plaintiffs' relief, and it affirmed the dismissal of the case. Specifically, Holmes made clear in his very strained logic that the relief sought by the plaintiffs merely being added to the voter rolls, all right, was essentially equitable in nature. It was the an action in equity, all right? And under the federal guidelines, an action in equity can only be brought when this was the appropriate, course to proceed under, all right? In Holmes's mind, that was not the appropriate course to proceed under, all right, as other methods were available. And of course, knowing what we know about, an action in equity, you only pursue that when there's no other remedy available, all right? And to add to that point, even if the court had ordered, the relief sought by the plaintiffs, it would make little sense to simply require they be added to voter rolls if the system was in effect illegal, as the plaintiffs were asserting. The court never gave a definitive answer one way or another on whether or not the system was unconstitutional or constitutional. It effectively dodged the question altogether, holding that, the system, we're not going to say that it is valid, but we're not going to specifically declare it unconstitutional either, all right? Based on the type of relief plaintiff is seeking, the court dodged that specific question as a way of getting out of giving finality on the subject at hand, okay? And next, the court invoked its decision in Hans versus Louisiana some 13 years earlier, where it had ruled that the 11th Amendment would preclude the federal court here from ordering the state in any way, shape, or form, all right? So Holmes made his argument that when the state here is out of the picture, then the court itself would have to essentially be the guiding force and the one calling the shots over the state's election system. And the court, as Holmes admitted, had virtually no power over the Southern white supremacists, as they were hell-bent on keeping African Americans from voting, okay? So Holmes is making the argument here that if, we do all this, then we will have to monitor Alabama's election process. And that's not something that the court is essentially empowered to do, all right? Holmes argued that the denial of blacks being able to vote here, in his mind, was a political issue, one that had to be resolved, and I quote, this is what Holmes said, apart from damages to the individual, relief from a great political wrong, if done as alleged by the people of a state and the state itself, must be given by them or by the legislature, by the legislative and political department of the government of the United States. So Holmes is saying that Congress must step in here and pass a piece of corrective legislation under the 14th and 15th Amendments to correct Alabama's obvious unconstitutional action. All right. So essentially, for all intents and purposes, the plaintiff was out of luck. Dismissal affirmed. However, 3 justices refused to accept Holmes's tortured logic here. Justices David Brewer, John Marshall Harlan, and Henry Billings Brown all dissented from Holmes's majority opinion. Justice Brewer, whose dissent was joined by Justice Brown, wrote a lengthy opinion on how the court obviously did have the jurisdiction here to deal with the subject matter at hand, all right? And if it was such a problem for Holmes in wrestling with jurisdiction, whether or not the federal courts had the jurisdiction, he should have obviously seen by the clear language of the Constitution and other relevant statutes that the federal courts certainly did have jurisdiction over the case. And Justice John Marshall Harlan would argue that the court absolutely, certainly could have dealt with this a different way as well in settling the matter based on the amount in controversy issue, not seeking to effectively abdicate its position here. You know, the federal courts most certainly had jurisdiction over the matter, all right? The Constitution and other relevant federal laws empowered the court here to be able to deal with this very thing, all right? But 'tis no matter. The dissenters only matter when their perspective is adopted by a later majority. Just want to point out some things with this case. Giles versus Harris, like I said, represented the court's most recent, at the time, capitulation to the forces of white supremacy. It was written by Justice Oliver Wendell Holmes, who had only been on the court a few months at that point, having been nominated by President Theodore Roosevelt and confirmed in December of 1902. So Holmes is pretty new on the Supreme Court, and this was arguably his worst opinion in his 3 decades on that judicial body. Okay? It is a decision that undoubtedly drew the anger of his appointing president, Theodore Roosevelt, who never supported or encouraged discrimination against African Americans. All right? Also, another bit of irony, Justice Henry Billings Brown, the author of the notorious vilified Plessy versus Ferguson decision some 7 years earlier in 1896, joined the dissenters, as you saw. Justice Brown, who in Plessy had affirmed state-sponsored racial segregation, joined the dissenters here, arguing, essentially joining Justice Brewer's dissent, that there was, clear evidence of discrimination, essentially, and that, the federal court certainly had the ability to correct this. Guess what, Justice Brown? Your decision in Plessy helped facilitate this. Constitutional law is cumulative, folks. No decision stands alone. Each decision has an effect, all right? And each decision has a result on society. I guess I'm going too far in to say that Justice Brown maybe was having remorseful beliefs at this point. Maybe my Plessy decision wasn't such a great one indeed. 'Tis no matter. Nonetheless, he did join the dissent, and obviously he saw that this was clearly an unconstitutional practice. But the court refused to use its power to challenge the white supremacists here in this case. And thankfully, though, the effect of Giles versus Harris has no longer any real force on constitutional law, as the decision has been overruled by a litany of different voting rights cases where the court certainly has used both the 14th and 15th Amendments to the Constitution to strike down unconstitutional voting restrictive practices by the states. Okay, so that is Giles versus Harris, folks. If you have any questions or controversies, leave them down below and I'll be happy to answer them. If you like this video, drop me a like. All right. If you didn't like it, put a dislike. All right. Let me know where I need improvement. All right. If you have not subscribed to my YouTube channel, please do so now. Your support would be greatly appreciated. Just hit that little red subscribe button and we'll be in business. And last but not least, if you'd like to donate financially to my channel, links are provided on the main page for you to do so. Thank you so much again for listening. Take care. Stay safe out there. And I'll talk to you at the next bite. Peace.